I'm Lynn Paltrow, founder and executive director of National Advocates for Pregnant Women. We're an organization that works to ensure that people who become pregnant retain their civil and human rights, and that no one fears that they will be or are actually subject to arrest, detention, or forced medical interventions because they're pregnant or for any outcome of pregnancy, including miscarriage, stillbirth, abortion, or having a baby. For those of you who are watching who work to protect and advance the right to abortion, you probably are wondering what the war on drugs or the fight for drug policy reform and harm reduction have to do with you. So you've come to the right place. We have 3 speakers. I'm very honored to be doing this with Deborah Small. She's founder of Break the Chains, communities of color challenging the war on drugs. I met Deborah when she was at the Drug Policy Alliance and was Director of Public Policy and Community Outreach. And you may have seen her as one of the people in the movie The 13th, the documentary The 13th about race, justice, and mass incarceration. Deborah will be speaking first, giving us all a background on the war on drugs and some of the themes that intersect and overlap that you will recognize with the war on people who get pregnant, the war on women, the war on abortion. I will be speaking next, and then Amber Khan, senior staff attorney here at National Advocates for Pregnant Women. We'll be talking about a current case in the federal court system that you probably missed because it isn't on its face about abortion. And in addition to her being a senior staff attorney here, Amber Khan is also the author of an article this summer in Ms. Magazine called The Crime Was Pregnancy. So I'm going to turn this over to you, Deborah, to start.
Okay, so good greetings to everyone who's online. I would say good morning because it's morning here, but for many of you, it's already afternoon. I'm really happy to be here joining Lynn and Amber on this important conversation. And I really appreciate the willingness of people to go outside of their normal area of focus to expand their view. So for some of you, this may be history that you're familiar with, and if so, forgive the redundancy. But for those of you who are not aware of the history of the drug war and how much it parallels the history of the war on abortion, I want to start by talking about that our drug policies from the very inception have been rooted in racism. When you trace the history of drug prohibition and what we now call the war on drugs, you discover that its roots are very specific. Almost every major prohibition that we have on drugs is linked to an issue of economic anxiety and racial animus. So the first drug laws that we had were directed at drugs that were widely used. You'll see in the slide advertisements for cocaine, toothache drops, and Bayer, which produced both aspirin and heroin, which were used widely during the 1800s. They were unregulated. As I pointed out, Sears and Roebuck would send you a syringe and a small amount of cocaine for $1.50. It's almost unbelievable to think of that, but that was actually the case, in part because this was considered a remedy, and they were used for pain relief and less widely for recreation. Next slide. Similarly, there was a time when abortion was simply part of life in the United States. From the founding until about 1880, abortions were allowed under common law and practiced widely. The only restriction on a woman's ability to have an abortion was after what was called quickening, which was a term that was described when the woman could actually feel the fetus moving. But drugs to induce abortion were a booming business. They were advertised in newspapers, could be bought from pharmacists, physicians, and even through the mail. And so you can see the parallel that these were activities that were part of the culture, that were businesses that catered to people's needs. But in the mid to late 1800s, states began passing laws that made abortion illegal. One of the motivations for these laws coincided with major problem around immigration, fears that people began having about the large number of immigrants that are coming into the country, and that somehow if you did not, that white people who were the ones who were perceived to be having abortions, that their birth rates were dropping, and that if you didn't make them continue to have babies, that the country would soon be overrun by the various immigrant groups that were coming in that were primarily not white Anglo-Saxon Protestants. In addition to the desire to combat what was called the scourge of immigrants in the country, there was also the desire of doctors who were just beginning to become a professionalized practice to establish for themselves the exclusive right to practice medicine. So they wanted to basically put out of business midwives, apothecaries, homeopaths, and the other people that working people normally turn to for healthcare, particularly for things that did not require some kind of surgical intervention. Next slide. So at the top, this is basically a slide of some of the products that were sold during that time that were available for women who wanted to get abortion. I thought it was interesting that the female pills were described as being fit for any kind of obstruction or conveyance that might have been in the body. You also see this picture I love of the midwives working together to help a woman to deliver. That was one of the things that doctors found very threatening, because midwives worked collectively. They were familiar with the women that they worked with. They had personal relationships with them, and they weren't as profit-driven as the doctors. And so they posed a real threat to their ability to establish themselves professionally. This picture, I think, is really important because it shows the beginning of the demonization of women who were midwives. This woman was called the wickedest woman in New York City because she provided abortions to women who needed them. And you see in this photo, her hands is a baby that looks like it's being eaten by a vampire bat. And that was the beginning of the kinds of media coverage, et cetera, that was geared towards criminalizing women who performed abortions. Next slide. During the same period of time, you also had the beginning of what was considered to be a major increase in opiate use in the United States. And in fact, it's true that at the turn of the century, per capita, in terms of population rate, US had the highest rate of opiate consumption that it's ever had in its history, including right now. There were at least 250,000 people in a population of 76 million. And the press began to condemn the problem of opiate use, but they linked it very much to the immigration of Chinese and to the existence of opium dens that had begun to be developed in Chinese communities and that were considered to be places that were used to lure white women into having sex. And one of the things I think that's important about, next slide, that's important about the history of drug policy in the US is that it was very much linked to this notion that we needed these laws in order to protect women, particularly white women, from the predations of lower class and minority men who would use these drugs to seduce them. So here you have a statement that was made by Dr. Hamilton Wright, who was one of the first major anti-drug crusaders, who says it has been authoritatively stated that cocaine is often the direct incentive to the crime of rape by the Negroes of the South and other sections of the country. One of the most unfortunate phases of smoking opium is the large number of women who have become involved and were living as common law wives or cohabiting with Chinese in the Chinatowns of our various cities. So again, you see this deliberate linking of quote unquote miscegenation and unrestricted racial interaction as being one of the occurrences or the effects of these illegal drugs. And it was these attitudes that were used to promote the first laws against drugs. Next slide. Here you see the kind of advertising and conversation that went along with the earlier statement about the increase in violence associated with Black use of cocaine. In 1914, the New York Times published a major article entitled Negro Cocaine Fiends, A New Southern Menace, which said that sheriffs had to increase the caliber of their weapons in order to bring down Black people who were under the effect of cocaine. Now, here's one of the comic book depictions of the unstoppable Negro, and you see him here, again, trying to assault sexually a white woman. And yet, as we know, then and now, these things were all made up. There was never a time where Black people were raping white women at the rate that they were being accused of and killed for, nor were they using drugs disproportionately to the white population. Next slide. Last one about the drugs. So I think the story about marijuana and Harry Anslinger is important because each of these wars, in the case of abortion, you had Comstock. In the case of narcotics, you had Anslinger. And these were right-wing people who were both bigoted, prejudiced, and anti-women, who used their positions of authority to engage in campaigns to target the groups of people that they saw as a danger to society, which were almost always racial minorities, recent immigrants, and women who were not behaving appropriately. So Harry Anslinger was the person most responsible for the initial prohibition of marijuana, for its association with Hispanics, for what we now call the reefer madness conversation that still exists in some parts of our country. And he was also responsible for building the Federal Bureau of Narcotics from a small little few people agency to one of the largest agencies in the federal government. And like Herbert Hoover, he was able to hold his office for more than 32 years, which allowed him to continue to build the drug prohibition rhetoric and to make sure that drug policy was always racialized and associated with minority groups. Next slide. This is a picture of Anslinger and some of his statements. He says that there are 100,000 total marijuana smokers in the US. Most are Negroes, Hispanics, Filipinos, and entertainers. Their satanic music, jazz, and swing result from marijuana usage. This marijuana causes white women to seek sexual relations with Negroes, entertainers, and any others. And then this one, I think, sums it up. Reefer makes darkies think they're as good as white men. I mean, if there was ever any question about the deliberate racialization of our policies, it's no coincidence that given these conversations that we live in a country that disproportionately arrests Blacks and Hispanics for crimes that are committed at equal rate by white people. Next slide. This is one of my favorite jazz artists, Billie Holiday, a photo of her on her deathbed. Most people know about her music and they know about her heroin addiction, but they don't know that she died under police custody. That Anslinger directed and ordered the New York police to come to her hospital, to place her under arrest, to handcuff her to her bed and charge her with heroin possession at the time that they knew that she was dying. And this to me is an example of the relentlessness of the war on drugs and the particular way in which women have been targeted and continue to be hounded by law enforcement when what they really need is health care and support. Next slide. So again, the modern war on drugs that we associated with Richard Nixon, many people believe that it was in response to the increase of drug use of soldiers in Vietnam. But the principal reason was told to one of the authors, Dan Baum, to Ehrlichman, who said that the Nixon campaign had two enemies, the anti-war left and Black people. We knew we couldn't make it illegal to be either against the war or Black, but by getting the public to associate hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying? Of course we did. So again, this is the ways in which our drug policies have been used as a way to target people. Next slide. Next slide. Right now, there are more than 1 million women on probation and parole. 2/3 of the women incarcerated have at least one minor child, and approximately 5% are pregnant at the time of their incarceration. Pregnant women who are incarcerated typically have to give birth in chains and shackles. I don't see how that's very different from what we did to Black women during slavery, who, when their owners wanted to punish them, would dig a hole and put them face down so they could beat the woman without hitting the child, somehow thinking that that torture wasn't going to affect the fetus. Next slide. Next slide. The point of that previous slide that I passed through for time was just to make the point that the people who end up being targeted for arrest and prosecution and incarceration are usually women who've already suffered, women who have already experienced rape, trauma, physical abuse. Almost 90% of the women behind bars in our country are people who are survivors. And so to me, our drug laws and policies act in a perverse way to punish those people who are the most vulnerable and who society has given the worst deal to. I'm going to just summarize by talking briefly about 10 tools of the drug war that can be now used against women who are seeking abortions. Conspiracy laws, guilt by association. We've been using them in the drug war for years. If they decided to apply that to women who have abortions, their families, their friends, even people who drive them to the places can be considered co-conspirators in breaking the law. The use of confidential informants, which makes friends, family, lovers subject to being interrogated to find out about the woman's activities. The use of surveillance techniques, including personal surveillance and digital surveillance. The idea that what you post on Twitter or Facebook or have in your communications with people can be surveyed by the government to find out if you're seeking an abortion, planning an abortion, or had an abortion. The idea of mandatory testing that we've been using in drugs for years now could also be applied to pregnancy, to force women to submit to tests, to find out if they're pregnant, and once pregnant, to have them be tested regularly to make sure that they don't miscarry or in any other way do something that's considered harmful to their pregnancy. Police entrapment. I mean, again, one of the main tools of the drug war is the use of stings and false advertising as a way to lure people in so that they can then be charged with crimes. We could easily see that being applied in the abortion context to women who are online or in other places seeking information or seeking the drugs that they need for chemically induced abortions. Mandatory sentencing, which we've had now for more than 25 years. We haven't reached that point, but it would not be too crazy to think that some states would try to apply mandatory sentencing to women based on the number of pills that they acquired, incomplete pregnancies, or any other standard that they sought to use. The involvement of child welfare, which can be used to coerce women to give up information and to submit to legal authority that they might not otherwise out of fear of losing their children. Public exposure. Right now, when people are arrested for drugs, many police departments put their names and faces on their local Facebook pages so that everyone in the community knows what has happened to them. We could see those kinds of things being tactics applied to women who are seeking abortion or who have had abortion. The prosecution of service providers, we know that's been threatened in many states. And this last one, which could be some of the most damaging to people permanently, is civil asset forfeiture. We have laws all over the country that allow the police to seize people's cars, their bank accounts, their personal property, if they deem that any of it was used in the commission of a crime. And so all of these tools that have become part of the repertoire of the drug war, we could see being applied to women who are seeking abortion. And I'll stop there.
Thank you, Deborah. Okay, there we go. So I'm going to talk now about some of the very specific ways in which there are connections that I've seen. I started my career defending the right to choose abortion and wanted to learn how abortion was criminalized. And you've heard some of that from Deborah. How was it also that it became legal? And one of the things that happened in 1962, in the 1960s, was this incredible case that made national and international news. Sherry Finkbein, mother of 4, was a host on a TV show that some of you listening may remember called Romper Room, where you had good doobies and bad doobies and you learned how to be obedient children. She then took a drug called thalidomide. And because that drug is one of the very rare and very few that actually causes fetal disruption, children born to women who took that medication were born with missing limbs, arms and legs, and other serious malformations. The interesting thing that I did not know until recently is how she came about getting the thalidomide. It turns out her husband had been working in England. He got a prescription for thalidomide, which was provided and sold as a sedative, a tranquilizer. He brought it home with him. Sherry used it. She was happy to be pregnant, but she was having a lot of, I guess, nervousness and anxiety. So she took the thalidomide, which would today, and after Nixon's war on drugs, would be a crime. It is a crime to take somebody else's prescription medication. And so while I think there are lots of people who are very active in defending the right to choose abortion and think these issues and movements are completely separate, it's meaningful to me that Sherry Finkbond could have been characterized as a drug criminal for using her husband's prescription medication, which she only then learned afterwards was could be so damaging. She sought to have an abortion in Arizona, which was, she was going to be able to have it. When she made public the reason for it, because she wanted other women to know how dangerous thalidomide was for pregnant women, unlike most other drugs, they refused to perform, to let her have the abortion there, and she had to fly to Sweden, and her life became defined as by this act of courage and her and stepping out of the country to have an abortion she could not get here. A more recent example, though, is in Wisconsin. The whole crack baby scare, and if you don't know this, it turns out that the science is very clear that there are no specific set of harms or syndromes to children born from as a result or after prenatal exposure to cocaine or any other of the criminalized drugs. But people in the pro-life movement, in the anti-abortion movement, used the crack baby scare to get Wisconsin to pass in 1998 the Unborn Child Protection Act. And the thing about that law is we know that the effort to overturn Roe v. Wade is, there are multiple approaches to doing that, including the trap law that will be tested again in the Supreme Court in the Louisiana VG case. But another mechanism for challenging Roe v. Wade is to have fetuses, or really the unborn from the moment of fertilization, recognized as separate persons, so that the government can outlaw abortion and really take control of anybody with the capacity for pregnancy. What the crack baby scare did, even though by the time they got the law passed, the science was clear that this was not, focusing on pregnant drug-using women was not the primary, was not an appropriate concern. The panic was inappropriate. They passed the law, and the law includes over 300 times it uses the term unborn child. It gives the state the power to lock up, to detain and lock up any woman who is pregnant and quote unquote habitually lacks self-control in the use of alcohol or a controlled substance. The standards are completely vague, and it has been used repeatedly to lock up women who have gone for help while pregnant and trying to deal with a drug dependency problem. So you have something that looks like, well, this is just about drugs. We're just trying to stop pregnant women from using drugs or protect their unborn children by taking them into custody. But it became a mechanism for really passing the only state law that is explicitly a personhood measure. And the interesting thing about it is, under the law, the fetus has a right to a lawyer. the fertilized egg, embryo, and fetus have a right to a lawyer at the initial hearings that can have the woman locked up, but the woman has no right to counsel at those hearings. And what that meant in the Alicia Beltran case, when Alicia went in to say, I'm so proud of myself, I've overcome my addiction problem, I'm so happy to be pregnant, all they heard was that she had previously used a drug, she had previously used a medication to help her wean herself from that drug, and they immediately reported her. She was arrested. She was taken before a court, a civil child welfare court, which was completely confidential. She had no lawyer. A lawyer was there for the fetus. And the only way she could articulate her human rights, her right to defend herself, was to ask, what if I choose to get an abortion? And she said it 3 different times. What if I choose to get an abortion? What if I ended this pregnancy now? And when the court finally deigned to respond to her, the court said, you need to ask the advice of your attorney. So what the Unborn Child Protection Act in Wisconsin did was create a mechanism for preventing an adult woman from having an abortion unless she has a lawyer and goes to court. So you can see how the war on drugs and the mythology around it and the stigmatizing, particularly of pregnant women who use drugs, had a direct line to creating a mechanism not only for creating precedent of so-called personhood a recognition for fertilized eggs, embryos, and fetuses, but also for preventing a woman, once taken into custody because she admits to some history of use of alcohol or any of the controlled substances, to prevent her not only from getting the healthcare she actually needs, being in the community with the support she needs, but also to prevent her from having an abortion. We've been working with this organization to fight the law there called Act 292, which requires people to really understand the intersection of the war on drugs and the war on abortion. In Alabama, they passed the Alabama Chemical Endangerment of a Child Act. It was supposed to be about punishing adults who take children to meth labs. There was probably very little opposition to it in and of itself, even though the claims made about the relative dangers and the value of another criminal abortion law should have been challenged. It quickly became a mechanism for arresting pregnant women who used any controlled substance, even one prescribed to them by their doctors. And the thing about that, again, is that we challenged that case. We challenged that interpretation of the chemical endangerment of a child law. It went up to the Alabama Supreme Court, and they used it as a mechanism for not only declaring separate rights for fertilized eggs, but explaining how Roe v. Wade should and can be overturned. And then in Tennessee, in response to what is perceived as the opioid crisis, Tennessee was the first legislature to pass a law expanding its fetal assault, its assault and other criminal laws to apply to pregnant women. They claimed it would be used to help encourage women to get treatment so their babies would not be born with the treatable transitory withdrawal syndrome called neonatal abstinence syndrome. But we knew from the beginning that it was also a mechanism that would be, and in fact ended up being used against women who have attempt or actually have self-abortions. The statute passed in the guise of a drug law, of addressing something that there's greatly stigmatized, was then used as one of the charges against Anna Yoka, who had attempted to have an abortion using a coat hanger. Happy to say we were able to help get those charges dropped. But again, the direct link between a drug war idea and an anti-abortion idea. And Kenlicia Jones, who was arrested for malice murder. She had obtained misoprostol and mifepristone. She ended her pregnancy, ended up at the hospital, and we were able to get the charges, the murder charge dropped against her. But what remained, and this is really telling, is that they kept a charge of possession of a dangerous substance, a dangerous drug. And in Georgia, misoprostol is listed as a dangerous drug along with all of the other drugs we associate with the war on drugs. And misoprostol is not a dangerous drug. Neither misoprostol nor mifepristone are. They're recognized, approved medications for a variety of reasons, and very safe for ending pregnancies in and outside of approved medical settings. We also have the Jenny McCormick case, a case in which a woman was also obtained medication and to end her pregnancy, and she was arrested under Idaho's criminal self-abortion law. And what I want to say there is she was represented by Rick Hearn, by amicus, including National Advocates for Pregnant Women and other organizations. The Ninth Circuit threw the case out, or found that they could not use this law, criminal abortion law, among others, to prosecute Jenny McCormick. But it was really telling to hear what the Attorney General for the state of Ohio was saying and what they said in their brief. And they said that there are a long line of decisions commencing with Roe that militate against the proposition that legislation aimed at preserving maternal health, think about it, legislation aimed at preserving maternal health. And that legislation is what? It is arresting women who have self-managed abortions. And that they should be permitted in the name of maternal health to extend that to the mother's own actions. In this case, where else have we seen laws that are justified to protect health, the health of people? It is the drug laws. If we arrest people, they'll stop using drugs. It won't be dangerous. And you have that exact pathway laid out for criminalizing abortion. I'm ending with the Purvi Patel case, and I end there. It was a case in which a woman also obtained medications to end her pregnancy, was charged both with a murder charge, a feticide charge, and a neglect charge. One of the things that I hope comes out of this presentation is, in her case, which ultimately, where it became clear that she had been arrested because she had had an abortion, there was extraordinary national outcry. And that helped to get her the representation and the support that ultimately had the feticide, the murder of a viable fetus charge, thrown out. But she also had a charge for neglect, the theory being that she neglected her unborn child before birth by using the medication, and then after by not calling, I guess, an ambulance in the 3 seconds that would have made no difference at all. But again, there was a national defense of her. Similarly, in the recent Marche Jones case in Alabama, there was a real national outcry for a case in which a woman was prosecuted, was being charged with the fetal assault crime that was no longer in place, and other crimes for putting herself in a dangerous situation in which she got shot while she was 5 months pregnant. And again, there was a real national outrage. What I noticed is that neither of those cases involved allegations of drug use, that it is very easy for people to want to defend people who are being arrested in relationship to their pregnancies, as long as it doesn't have to do with drugs. And we need to recognize that every person, whether they use drugs or not, who's being arrested in relationship to their pregnancies needs to be vigorously, wholeheartedly, collaboratively defended. And the last thing I want to say about both the Purvi Patel case and the Kenlicia Jones case is ultimately the neglect charge was downgraded in Purvi Patel's case, and the malice murder charge was thrown out in the Kenlicia Jones case, because there was precedent from earlier cases in which women who used drugs and were pregnant and drug use had been prosecuted. People had come in and defended them and established that criminal laws in those states, Indiana and Georgia, could not be used to hold women criminally liable for what they did or didn't do while pregnant, or for the outcome of their pregnancies based on having been pregnant and doing or not doing something. We look forward to having the benefit, as we look at the potential end of Roe, of working across movements to challenge that. And in order to pay attention Oh, by the way, please send in questions. If you have questions, the question and answer part of this Zoom is open, and we'd be happy to answer them. We're going to have time for questions. And I'm turning this over to Amber Khan, who will be talking to you about a case that you probably haven't heard about.
Thanks, Lynn, and thank you, Deborah, for all of that information, and to everyone who's listening to us today about this topic. So, as Lynn had said, we're talking about a case specifically in federal court that may not be on people's radar in the same particular way because it's not about a specific abortion regulation. But this is a case that certainly can impact the rights of pregnant people, including the right to abortion. So there is a case, it's a woman named Samantha Flute, and her case is currently pending before the 8th Circuit Court of Appeals. Back in 2016, Ms. Flute, a Native American woman in South Dakota, went to a hospital. She was in labor, and she gave birth to a baby boy. Unfortunately, he passed away a few hours after he was born. Ms. Flute, for reasons that are kind of entirely unclear, was drug tested during her labor and delivery. And there has never been a great explanation as to why she was drug tested. It doesn't seem like she was given, that she gave any kind of explicit consent for this drug testing, but it did occur. And she tested positive for cocaine. And also she was questioned afterwards about her past drug use, and she shared a lot of information about her history. Her son also, there was an autopsy done because the hospital was concerned as to why this child passed away. As a result of all of these things, Ms. Flute was arrested for manslaughter. And what had happened is that this hospital and all of these things occurred on a reservation. So because of that, this case also came under federal jurisdiction. So she faced federal manslaughter charges. Ms. Flute was represented by the federal defenders who argued the case, and they argued that it should be dismissed. I mean, just the manslaughter statute is not intended to prosecute people for their actions during pregnancy. The statute is pretty specific to prosecuting someone who kills, harms another human being. And that's just not the circumstances of this situation. And the district court in that case agreed and dismissed the charges. In the decision, the district court actually addresses the Federal Unborn Victim Violence Act. And specifically what the court talks about is that when this federal law was passed, it did extend the class of victims to include the unborn under certain circumstances. But it was also passed to explicitly address the actions of third parties, actions that are taken against pregnant people. And the point of the law was actually to protect pregnant people and to protect the constitutional rights of the pregnant person, and only to address someone who kind of commits an act of violence against a woman. This is also why the statute really is explicit, the Unborn Victim of Violence Act, and really specifically explains that a pregnant person cannot be prosecuted under it for anything that happens during their pregnancy as it pertains to the pregnancy. Unfortunately, this case was then appealed by the government. So even though the district court, acknowledged all of these things, talked about why the statute cannot be used to prosecute Ms. Flute, talked about the history of other federal laws and how they were never intended to prosecute pregnant people. In fact, even went on to say that if this type of prosecution is allowed to proceed, it really can open the door to lots of things happening to pregnant folks in this region, and specifically the fact that it can open the door to people being prosecuted for things that are just otherwise legal if a particular prosecutor thinks they could be harmful. Everything from whether it's drinking alcohol or not receiving prenatal care, a lot of things are just going to come up. And that certainly can open the door to these laws being interpreted in a way that a person could be stopped from having an abortion. It's kind of just opens the door to many factors, and it can't happen. And so the district court, issued this decision and said Ms. Flute can't be prosecuted. However, like I said, the case was appealed to the 8th Circuit, and the government argued that Ms. Flute should be able to be prosecuted. And unfortunately, what the 8th Circuit did was reverse this decision, and they remanded it back to the district court. The Eighth Circuit looked at the statutes at issue just very differently. What the Eighth Circuit found was that while the language of the Unborn Victims of Violence Act does have this explicit provision that a pregnant person can't be prosecuted under it, what they said is that that part just isn't relevant. That what they really wanted to focus on was just the manslaughter statute. And since the manslaughter statute does not explicitly state that a person can't be prosecuted for actions during pregnancy, that they're going to allow it to proceed. And even though they acknowledged, that the district court had really serious concerns of what this type of expansion of the law could do and how it could harm pregnant people, they kind of said that that's not what they need to worry about. All they want to look at is just the manslaughter statute. It doesn't explicitly say that, Ms. Flute can't be prosecuted. And so even if it does open the door to all this conduct that Congress never intended to criminalize, even if it poses these risks to pregnant people, that's not what's before them, and it's going to go forward. So the case got sent back to the district court, and this took years, but Ms. Flute currently still has this open case. So what the federal defenders did next, and this is where NAPW also was involved, is they filed a petition to the Eighth Circuit asking them to reconsider. Just explaining the fact that this case obviously has some pretty large and serious consequences for Ms. Flute and also the rights of pregnant people, and that the entire court should really be looking at this. NAPW filed an amicus brief with allies, a friend of the court brief, to really support Ms. Flute and explain how such an expansion of the federal manslaughter statute would be really harmful. It's harmful to the public health. It would certainly deter people from seeking healthcare and just scare them if they think that, if they can't guarantee a positive pregnancy outcome, that they could be going to prison for the rest of their life. But also to show that this would have a really disproportionate impact on Native communities. One of the things that the brief highlighted is that studies show that certain populations, specifically people of color and poorer people, are more likely to be drug tested while pregnant and during labor and delivery. And that since, Native folks are this particular case certainly involves a Native American woman, but Native folks in general are disproportionately also impacted by poverty, lack access to adequate health care, and have higher rates of infant mortality. So if you kind of take all of these things together, then what you see is that certain populations are just more likely to be targeted by this prosecution. And I think that really, also goes back to some of the things Deborah was explaining about the history of the drug war and the populations that are targeted in certain ways, not only for surveillance, but who's likely going to be incarcerated and who's likely going to be targeted by these types of government actions. And so what the brief also wanted to do was explain how all of these things could happen in South Dakota and in the other regions that are impacted by the Eighth Circuit. Now, so far we don't know yet what's going to happen. The matter is actually still pending in the Eighth Circuit. They haven't yet decided whether or not this case is going to be re-examined or not. But these serious implications that it has, really impact a lot of things about pregnancy, right? And all the ways that a pregnant person can be surveilled. And also, again, highlighting how certain populations can be surveilled. But to take a step back outside of just the criminal context, we also look at this region and we look at what's going on. South Dakota has a series of really kind of problematic laws in how it deals with what should be health issues. So, this is a case about drug use, but there's other civil laws also, state civil laws in South Dakota that cover some of these topics. So, for example, South Dakota is one of 4 states that allows its civil commitment process to be used against pregnant people. And South Dakota is really specific. That says that if a person is pregnant and using a controlled substance, they can be civilly committed. South Dakota also has a civil child abuse law that states that if a child has been prenatally exposed to a controlled substance, that child is automatically considered abused under the law, which means that child can, be removed from their parent, placed in foster care, their family can face all kinds of punitive consequences. So they have a set of these laws that are addressing drug use and a health concern, but they're using these punitive ways to address these things. What South Dakota is not doing is actually putting any kind of resources towards treatment and advancing healthcare. South Dakota, in fact, that has, much like a lot of the country, has limited access to drug treatment to begin with, but specifically it has no program that actually is meant for pregnant patients. So considering that this is, the underlying health concerns of what's going on, this response by the government to treat people, especially if they do have a substance use disorder, but to treat people in a way that uses punitive actions, whether it's the criminal system, the civil system, the child welfare system, rather than thinking about ways that could actually protect people's health, is hugely problematic. And all of these things together, Ms. Flute's case certainly is a very specific federal example of what's going on in the court system, but it's also just kind of worth thinking overall how all of these policies are undermining the rights of pregnant people and have a particularly disproportionate impact on certain populations. That certainly addresses abortion, but also so many other things that are impacting the folks in that area. So Lynn, I think that gives the example of Ms. Flute's case. And now back to you.
Thank you. And we have some questions that we'll get to in a minute. I'm good. Thank you. I'm going to conclude just by the observation that we live in a country where we pass laws, prohibition laws, and yet we know they don't work, right? So you prohibit people from drinking alcohol and they still drink alcohol. You prohibit people from possessing certain drugs and criminalizing everything around them. And as we know that has utterly failed. And before Roe in 1973, when abortion was criminalized, when it was illegal, it was estimated that between 200,000 women and 1 million each year had abortions. So if people know that prohibition doesn't work, doesn't actually achieve the purpose of stopping drinking, stopping the use of certain drugs, stopping abortions, why do they keep passing them? And as Deborah's talk particularly helps us understand that what prohibition does do is give state authorities the power to control certain populations, because those laws are never applied equally to everyone. They are used to control very particular groups of people based on race and economics and gender as well. And I think that we should be sharing a commitment to the notion that there is no role for a criminal law, for the criminal law system, when it comes to matters of health, what we put in our bodies, whether that's drugs or sperm, that there's just no role for the criminal law system. So we might have some questions for each other, but I'm going to start with an anonymous attendee asks, what basic approaches have worked to educate the public about some of the harmful legislation, particularly a public that is not so harm reduction minded? And I'm going to start with, and then turn it over to you two. I want to just give one example. There was incredible organized opposition to the Tennessee fetal assault law that was passed in 2014, which was a law, again, that pretended to provide a criminal law incentive for pregnant people with opioid dependencies to get treatment. They ignored the fact that treatment was largely unavailable and the state doesn't fund methadone. Community in Tennessee and nationally got very involved to say this would be counterproductive, that you don't want to put people in jail for health issues, that it would discourage women from getting whatever health care was available. And they didn't succeed in stopping the law from passing, but the outcry was pretty great, and they put a sunset on the criminal law, something I have never seen in any other criminal law, which said it will go out of effect if it's not reenacted in 2 years. And then groups including Sister Reach and Healthy and Free Tennessee and Memphis Choices and national groups and state-based coalitions all worked to make sure the law went out of effect in 2016, which it did. And part of that was a coordinated effort at education, including a conference, a national conference held in Nashville, Tennessee, co-sponsored by the National Perinatal Association, looking at the science, looking at the value of harm reduction, and showing through conferences like that and then research spearheaded by Sister Reach that the effect of all of these punitive laws is to make people less healthy. It does not save lives, any kind, born or unborn. Deborah?
So thank you, Lynn. I think the only thing that I would add is that I think one of the things that we tend to deny as a country when it comes to legislation is that all of these negative outcomes are unintended consequences. But the fact is that we actually know in advance what the consequence of doing these things would be. It seems crazy to me that a country that could get rid of alcohol prohibition in 12 years is still holding on to drug prohibition for more than 60, in spite of having the exact same kind of outcomes. And, you know, we forget that when physicians took over being responsible for women's health care and reproductive services, that women's negative outcomes went up in the years right after. There was a great increase in infant mortality when women were no longer providing care for each other. Eventually, with technology and greater skill, they were able to bring that down. But the initial impetus and outcome of that legislation was negative and harmful for women. So I think it's important for us to be willing to call out what's actually going on. It's not a coincidence that this war on women's wombs is occurring at the same time that women are increasing their level of political and economic power in society, in the same way that the drug war in the modern era was a direct response to the gains that were made by Black and brown people during the civil rights era. And so we need to understand the way in which these things work together and understand that we need a united response. That when you're fighting for reproductive justice, you're also fighting for racial justice. When you're fighting for criminal justice reform, you're also fighting for women's rights. So we need to see ourselves as a movement that's joined by the common desire to increase people's degrees of freedom and restrict the ability of government to impact it in ways that are harmful.
Amber, do you want to add anything?
I agree with all of that.
Do you want to read? Can you read the questions too? Do you see them?
Yes. Do you want me to read the next?
Yeah, why don't you do the next one?
Sure. So this is from Merritt. I feel like this has been one of the most informative and disturbing webinars I've seen recently. I'm an Indigenous Indie provider and like to think I'm fairly well informed, but I've been making a long list of things to research while listening. Could you share a suggestion of where one might start on the journey to be a better advocate for community members facing the intersection of these issues? So any resources that we recommend? There's of course many, so where to start? Deborah, do you have any specific recommendations you'd like to give?
Well, I just think Dorothy Roberts is a brilliant writer, and her analysis of these issues is so spot on in terms of reinforcing the intersectionality and the way in which they relate to racial justice and capitalism. So anyone who hasn't read her, I would start there.
Then there's some other, you know, we sort of come to our issues knowing something. One of the first books I read that helped me understand the madness of the drug war is called Drug Crazy by Mike Gray. It may be out of print, but it's totally available through online sources. Another book, High Price by Carl Hart. And there's another one that's just escaping me, but there are, and the one that Deborah cited, Dan Bound's book on the history of the drug war. They are so, you just see the parallels between these issues. One, I'm not sure it's in any of those, but just to mention is we have government funding that is for DARE, these programs that teach drug abstinence. We also have funding through Chastity Act for teaching sexual abstinence. And sometimes they just switch the money back and forth between those two pools of money, all of which are about the same thing, which is responding to people, what people actually do in their lives, and telling them that they shouldn't, and that they will be punished for doing it. you definitely can go to our website, advocatesforpregnantwomen.org. And the question, of course, will make us think about all of the other things we should have said as soon as this session is over. And we will post those and make them available to you as we work on this. And certainly the amicus brief, the brief that Amber was describing in the Flute case, will have a lot of very useful information. It's many of the amicus briefs, friend of the court briefs that we file are on behalf of leading medical organizations, public health organizations, and health experts. And they're very accessible, they're not overly legalistic, and they really explain why challenge the myths that are often motivating or being used to justify actions that not only are punitive against the individual, but would set precedent that can be used to arrest and detain pregnant people for everything associated that related to their pregnancies. Again, miscarriage, stillbirth, abortion, or even going to term. The next question is from Live. Oh, they look like there are a few more here. Another point of intersection are the drug-induced homicide laws that have been passed in several states, such as North Carolina. These laws charge people with who sold, supplied, or enabled people to use drugs with manslaughter. Even in my state of Ohio, which doesn't have an explicit laws charging people in this way, including recently charging a woman with manslaughter after she dropped someone off to purchase drugs and they later overdosed and died. That's a really good point. Deborah, do you have any more comment about how we keep making more and more things criminal?
Well, I mean, the thing I have to say about that is that these laws in part are the results of a misunderstanding about what's actually happening, that we're in a fentanyl crisis as opposed to just a heroin or opiate crisis, and that fentanyl is a synthetic drug that is being integrated into the drug supply, and that most of the people who die of fatal overdoses have no idea that fentanyl is in their drugs. So for me, I wish we had a different terminology other than overdose, because in my world, this is accidental poisoning. No one intends to take, even the people who are heroin users don't expect that their drug is going to be laced with something that's fatal. And so if we had an understanding that this was really about fentanyl, then we would support the idea of having safe consumption places, to have morphine maintenance programs, to make sure that people actually had a clean supply of drugs so that they didn't have to die unnecessarily. But because we see this as primarily a drug issue and a crime issue, then we're going to punish all the people around them, which doesn't save anybody's life. It only increases the number of people who are at risk.
That's right. And I think Blythe followed up with, can you share more about this space of intersection? And I just want to say that I really appreciated Deborah comparing Comstock to Anslinger. At a point where fewer and fewer people have access to abortion clinics and medical centers, approved medical centers for getting abortion, they are turning to what we now have, which are safe medications, Misoprostol and Mifepristone. You can go online to Plan C and learn more about it, and other websites that explain how these drugs can be used safely to end a pregnancy. But the government looks like it's gearing up to try to interfere with access to those medications. And that's exactly what Comstock made a career of, preventing people from accessing and getting through the mails contraceptives. And then Anslinger did what he did with the drug war. So this is just the intersections are not only that these mechanisms of prohibition that don't work and are used to control certain populations and reinforce racism. And I would say the combination of the war on drugs and, for lack of a better phrase, the war on abortion, they fulfill, as a New York Times editorial explained, two of Trump's promises to his base: white supremacy and male supremacy. And you put those two together and you have the agenda that our current administration seems to support. So those are some of the other places of intersection. Let me move on to another question. Well, it is from an anonymous attendee. Do hospitals have the right to drug test all pregnant women? I'll take a first stab at that, and which is to say that no person should be subject to any medical interventions or tests without their consent. As a matter of law, constitutional law and rights, as a matter of state law, as a matter of medical ethics. There are a few states, a handful of states, that do say that doctors are obligated to test if they suspect a pregnant woman is using certain drugs. Those are very few states. And otherwise, it's mostly a practice that in South Carolina, when it was done as a mechanism of not medical care, but of secretly searching women for evidence of drug use so that it could be turned over to the police. The United States Supreme Court, 6-3, said, you cannot do that. That violates a patient's Fourth Amendment protections from unwarranted searches and seizures. It's very complicated, though, for a person to argue that they shouldn't be drug tested when they often don't know it's happening, and when they've been given a blanket consent form to be subjected to a wide range of drug testing. I know we have a fact sheet on this, and I have a feeling that Amber could help articulate this even better.
Yes, I think we do have a fact sheet on our website for anybody who's interested in getting more information about it. You know, I think just to add to what Lynn was saying, that a lot of folks just don't know they're being drug tested. And what that really, you know, kind of demonstrates is that when someone is getting health care and they're consenting to testing, they're there because they want to give information. They want to be honest with their doctor and other providers. They assume that what's happening is meant to, you know, advance their health, to give them recommendations if they need, you know, something specific to do. What they don't think about is that if this testing occurs and they don't know about it, including drug testing, that what that doctor or other healthcare provider might do is actually violate that confidential relationship and take that result and give it to a government authority who can then use it to either civilly or criminally prosecute them. So, you know, it's that breach of that confidential relationship that I think people really have no understanding of. And there are certain states right now that are trying to actually pass specific laws to address this. Because as Lynn explained, there is this, you know, kind of difficult situation where A, you don't know you're being drug tested, and B, you've kind of given this blanket consent. And so if a healthcare provider wants to do the test, they do it. They also might think they're required to report the results of it based on some kind of child welfare or other law. And what it results in is a lot of people being prosecuted in a variety of ways and just being afraid to go see a doctor. So some states, including those that are led by doctors, are trying to propose legislation that really clarify that, you know, this privacy has to be protected, that people don't lose that right just because they are pregnant, and that everyone should be aware of what's happening and the potential consequence if this test occurs. So, you know, that's hopefully something that can be done to really protect the rights of pregnant patients.
Thank you. There's a question for you too. Is Samantha Flute at home while this is all being argued?
Yes. So since her case was initially dismissed by the district court a few years ago, you know, when it was dismissed, she was released. And then, of course, it was appealed, and the Eighth Circuit took over 2 years almost to make this decision. So she has been out this entire time, but unfortunately not knowing, you know, whether or not she can go back to prison or, you know, what's going to happen.
Great. And yes, somebody asked if the books in the follow-up to the follow-up email to this Zoom webinar, we will list the books we mentioned, and I'm sure a lot more. Here's a question that I appreciate, especially also from Merit. Do you have any starting point suggestions for talking points to engage potential stakeholders from recovery and recovery support communities who traditionally do not identify as pro-choice? And that's a wonderful question that too often we divide up and we're not going to talk to each other unless we agree on something or you're pro-choice. One of the things that really makes this intersectionality so clear is to be able to say to people, listen, you can oppose abortion. You might be working against it. You have strong moral feelings about it. But I think you need to understand that if the anti-abortion position succeeds, it will impact the ability for people to obtain treatment and achieve recovery. Because if abortion is criminalized, if abortion is outlawed, if it's seen as a crime, that is used to then hold people going to term criminally liable for the things they do. So for example, this is actually a child welfare example. In New Jersey, the argument was made using the anti-abortion idea of the fetus is really a separate person, that women who were pregnant and got into methadone treatment could be found guilty of civil child abuse because there can be a withdrawal sequence at birth. The argument was obtaining the treatment recommended by the World Health Organization and by New Jersey and by all people in the recovery and treatment field for folks who have opioid dependencies, that they still wanted to hold this woman liable for child abuse and neglect in the civil system. And that was not just a drug issue. That was based on the ideas promoted by anti-choice activists. And it's important to validate people feel strongly that fetuses have value, that they shouldn't be discarded or disrespected. But it is also helpful to walk through examples of what happens when the ideas underlying that commitment are used to prevent people from accessing treatment. The reason why Alicia Beltran and Tammy Lacher and Ms. Lowe in Wisconsin go for help to their doctors, and instead of getting help, they get locked up in jail, in a mental hospital, and in the end don't get prenatal care, is based on a law that was passed by pro-life activists, by people who use the fear of cocaine and pregnancy to justify a law that put into place their theory that they knew they could use in the abortion context as well as in the drug context. So there are many examples. You can find many of them on our website, but the point is that that will be helpful to have conversations about how anti-abortion ideology has been used to hurt people who do not want to end their pregnancies. Most of the people we've represented have been people who hold very deep religious views opposed to abortion, but who have been forced to have surgery, who've been locked up, who've been forced to undergo inappropriate treatment based exactly on those same anti-abortion ideology that they believe they support in another context. So we want to just say thank you so much for participating. This will be recorded and available. We'll do a follow-up email, and I particularly want to thank Deborah Small and Amber Khan for their extraordinary work and their words today that help us understand yet another intersectionality that makes us stronger when we work together. Thank you, everybody.